Aaya Ram Gaya Ram. The phrase became popular in Indian politics after Haryana MLA Gaya Lal changed his party twice in a few hours and thrice within 15 days. This was in 1967. A few years later, in 1985, the 10th schedule of the Constitution, which is known as the Anti-defection Law, was added to the Constitution, and while arguing for the bill to be passed, Rajiv Gandhi in the Lok Sabha on 30th January 1985 left quite an impression when he said, and I quote, "This bill is the first step towards cleaning our public life," unquote. On that day, at least 47 legislators sat together, debated the bill for almost 7 hours, skipped their lunch break as well. But since the law came into force and the bill has been passed, the huddling of legislators in farmhouses and flowing them in chartered flights to high-end resorts has continued. Political defections have continued. In this episode of Laws of the Land, we'll be talking about this law, anti-defection law. What does the law say and how impactful has it been? And for this episode, you have me, Apoorva Mandhani, you have Bhadra, Sinha, you know both of us. And we also have constitutional expert and senior advocate Saurabh Kirpal joining us, bringing in his expertise to talk about this law. Thank you so much for joining us, Saurabh.
Thank you so much for having me, but constitutional expert?
The jury's out.
Yeah, well. So, Saurabh, before we discuss the success or the failure of the law, we would just like you to, tell our viewers. Of course, Apoorva has given a little bit of background, but if you could tell more about the Aaya Ram Gaya Ram case, and why did the Parliament at that point of time think that it was important to have this law?
See, defection in India is as old as politics because people like to move from one party to the other. Earlier, it used to happen for ideological reasons. Yeah. Then the nature of the reasons started changing from ideology to certain other considerations. But the fact of people shifting from one party to the other has been a phenomenon which has been known to the Indian polity pretty much from the first time the elections were held in 1951 in our constitution. Interestingly, one place where it is most often done is a place which is very close to all of your hearts, I'm sure, and certainly to mine, is Goa. Goa was known for MLAs switching from one party to the other, and it's still happening. Yes. It's a proud tradition of the Goan people where they, being elected to one party means nothing. They will eventually go and move to some other party. So this was an endemic problem, and it was often seen when governments were weak that people moved from one party to the other. It happened in the 60s when the Congress party was in turmoil. At that point, there was a Chavan committee that was formed, Y.B. Chavan, who became the Home Minister. He came up with a suggestion to have something like a anti-defection law. Of course, then the events overtook that. There was the emergency, there was other turmoil in the country. And it is only when Rajiv Gandhi came in 1984, after the assassination of Mrs. Gandhi, and that massive parliamentary majority of over 400 seats that he had. That is when Rajiv Gandhi said, all right, let's bring an anti-defection law to curb defection, to stop people moving from one party to the other. Now, of course, that could have been a feeling that, yes, I'm doing good for the country, as was ostensibly said on the floor of Parliament. Or it could also be, but when you have 400 MPs, you are worried that you will start leaching out those MPs. Why is it that the government, which has such a vast majority, feels the need to stop defections happening? People are not going to jump to your party. You already have enough. So obviously the worry was people are going to leave my party and go elsewhere, right? Because like nature abhors vacuum, eventually all political parties see deterioration. So this was something done to stop that. And that is why in 1985, the constitution was amended. Something known as the 10th schedule, which you mentioned, which is about 7 articles, 7 clauses were inserted into the end of the constitution, saying under which and what circumstances people who move from one political party to another will lose the membership of the house. The idea was to bring, as you said, cleanliness, so that people, the idea is, of course, also more than cleanliness, is that when a voter votes in India, the idea is you're voting for a political party. You are not voting for that particular individual, you are voting for the party. So when that particular individual switches parties, that is seen as a violation of the democratic mandate. Now, I myself, I must say, I do not subscribe to this anti-defection law at all. Now, we can talk about this now, we can talk about it later.
No, we'll talk about it later because there is a lot of criticism.
Yes, absolutely. But as long as your idea is that you are voting for the party, then the anti-defection law makes sense, because that is then a violation of the mandate. So that was the reason why the 10th schedule was inserted. And a long, in India we also love to have long complicated legalese in our constitution, in our arguments in court, in speeches on the print. We love to, we love to speak. So here comes the 10th schedule. It is extremely long and delightfully vague. Yes. So in spite of it being long, you would have thought, hello, you are spending so much time, in closed type spaces of 7 articles, you clarify certain concepts, but they haven't. And of course, as an advocate, I'm very happy. The more the confusion and chaos, the more the scope for lawyers to step in and ambiguity to step in, which is also a good thing. And ambiguity in the law is not always a bad thing, no matter what people say. It gives room for growth. But the 10th schedule really actually came about to stop this.
So what are the circumstances under which disqualification petition can be filed against a member of the House? And who can actually file it? Can it be the entire political party or a particular person representative of a political party?
See, there are really 2 kinds of people who can be disqualified under the 10th schedule. First is, in fact, 3 kinds of people if you go technically by the law. There are 3 kinds of people who can be disqualified. Most importantly is if you belong to a political party and you've been elected to a political party and you jump from that political party to another political party. And how do you say jump? How do you determine jump? When you either act contrary to a whip. So as you know, in the Westminster model, which is our parliamentary democracy, the 3-line whip is issued by or indeed now even just a whip, by the whip managers, or the whips as they're called, who say you, our parliamentary party, will vote only in a particular manner, right? So when there is a bill that is being passed, you will vote in support or you will vote anti that bill, and that is called the whip. Now if you act contrary to that, or if you do certain other activities outside parliament, which are contrary to your assertion that you believe or belong to a political party. So for instance, you may say I belong to a party X and vote as per party X's directives in parliament because you're scared of losing your seat. But outside, on the ground, you do all activities which are contrary to party X. And in fact, you are seen on morchas with party Y, who is an opponent of party X. That will also incur disqualification.
So both inside as well as outside the parliament.
Inside as well as outside parliament, if your actions are non-commensurate or incommensurable with your action of being in a political party, you are treated as a person who has defected.
So that means a formal resignation isn't really required.
Formal resignation is not required, because you see, if you formally resign from a party or from your seat, there is no defection in any case. Right. Because what is the effect of defection? The effect of defection is the moment you swap your parties, you are thereby disqualified from your seat as MP, MLA or whatever post you particularly hold. Currently it's restricted to MPs and MLAs. So you will lose that post. So there is no question of a resignation, because the idea is to ensure that you are deemed disqualified. So that's the first kind of person. The second is a person who is elected as an independent MP or an MLA. You can't join a political party. So if you join a political party, then you are deemed to be disqualified. If once an independent, always an independent. Right? Rather like a lot of the viewers, I suppose, of print.
Yes.
A lot of us are, and I think that's a tragedy of Indian politics about how those in the middle seem to be marginalized. But that's another time, another topic, another debate. I hope you'll have me for that.
Yeah,
of course.
I'm keeping a tab on that. Like I'm just putting a pin there. Yeah.
And the third one is a nominated member of parliament. A lot of people are nominated. There's nominated seats under Rajya Sabha, etc. Even in the Lok Sabha, for Anglo-Indians there were. So you have, I think, 6 months after your nomination to determine whether you want to become a member of a political party. And if you do within 6 months, you join a political party, then you are not disqualified. But after 6 months, by which time I presume the logic is that somehow your views are crystallized, I never quite understood what is so important about 6 months. If you're nominated, you're nominated. You're supposed to be independent, but that's what Parliament in its wisdom thought. So you have a 6-month grace period, so to say, in which you can defect. But after the 6 months period, please don't. So that's the area.
So under the law, the Speaker is the final authority who decides on the disqualification petition. Now, does the law subscribe any any time period for the Speaker to decide a disqualification petition?
Yeah. Well, the law itself does not. You see, and that's something your viewers should also know. In 1985, I think when this law first came, the 10th schedule, there was a belief that the Speaker was a person who was removed from party politics. You were above that. And in fact, in our constitutional scheme of things, if you go by warrant of precedence, there is the President of India, the Vice President of India, then there is the Speaker and the Chief Justice of India, who are and then that's Prime Minister. Then fourth is Speaker stroke Chief Justice of India. They are put on a pedestal together. Right. It is an important constitutional post, Speaker, because you are meant to be an independent person who is like a judge in the House. Right. But the Chief Justice determines what happens in a courtroom in the Supreme Court of India or any High Court. The Speaker is effectively akin to a judge of the House and the proceedings of the House. And you're meant to be a neutral person above party politics. You may be elected on a party ticket, but when you come to adorn that important constitutional post, you are supposed to forget that. Right. But that is rather like fairyland. Ultimately, speakers are human beings. It's tough enough to expect anyone to forget their politics when they do ABC things. Speakers, as history has shown us, do not forget their politics. Right? So the idea in 1985 was, yes, Speaker, apolitical person, and therefore will judge whether someone stands disqualified or does not stand disqualified. But, and this was upheld by the Supreme Court in a famous judgment, and if you can pronounce it, good for you, Kihoto Holohan. That is a case where upheld this 10th schedule and said the Speaker is actually someone who carries this constitutional trust. But I think time has shown us that that is often not the case, that the Speaker has often acted in a partisan manner. And to your question about time frame, well, the Constitution does not say any time frames. As I said, even though it was such a long document, it could have provided, it hasn't. But our Supreme Court, by way of judgments, has clarified that you have a 3-month period within which you must make a determination. When a disqualification, you see, this was something used very often. When disqualification happens, things move at a rapid speed, which is what you alluded to, that people are whisked off in cars to various farmhouses, resorts.
So time is of great essence.
I don't know why we work so hard to get holidays. We should just become elected and don't go for holidays. As though someone's dying to elect us. We are the unelectable. Yes. But so the things are moving at a very rapid pace at that point of time. And one tool of ensuring that a particular side wins or loses is by the Speaker refusing to act on a disqualification petition. Because if you don't act on it and that person votes, you may disqualify them, by then the damage is done. Right? So that is why the Supreme Court stepped in and said that we are seeing this very often, that the Speaker only moves fast, and they sometimes move with lightning speed when it suits their particular political ideology, and in other cases will sit on it for years on end and not decide anything.
So with the Speaker, since you said they often act in a partisan manner, what recourse do disqualified legislators have in that case?
Well, theoretically, there is an ouster of jurisdiction of the courts. So the 10th schedule says the courts will not interfere. Right. But our courts have interpreted that and said that the power of judicial review will always be available. So if you are rightly or wrongly disqualified, and if there is violation of certain fundamental principles of law, then a constitutional court like the Supreme Court or the High Court can intervene, but on very, very limited grounds, and then judge the decision of the Speaker. But it very rarely happens. The Speaker is pretty much the final authority on this.
So you mean, do we mean that a judicial review is allowed against the Speaker's decision, or is there a judicial review possible when the Speaker doesn't act?
Well, the former as well as the latter. See, as regards when the Speaker takes a completely erroneous decision contrary to principles of natural justice, certainly judicial review will lie. So there you are reviewing the decision of the speaker. Right. Supposing you disqualified without hearing someone. Okay. That. But if the speaker doesn't act, that is what I said, the Supreme Court has had given a 3-month period. Saying that now as a matter of rule, you must decide within 3 months. Right. But like so many judgments of the Supreme Court, even this seems to be sometimes ignored. And there have been many instances of this 3-month rule being violated. In my understanding, it is certainly possible for a political party to go and say, well, look, you have this 3-month period. This speaker is not following this mandate of the law of deciding within 3 months, and it amounts to contempt of that order, which directs the speaker to decide within 3 months. Sometimes courts are reluctant to take on such tricky political decisions, and understandably so, because courts should be tried to be away from politics. But in some matters, courts do not have the option or the luxury of keeping away from politics. That is a constitutional responsibility cast upon the courts. So they're called upon to it, and they have no option but to do it.
And they've had, midnight hearings also on it.
They had midnight hearings, they've had all kinds of hearings. There is nothing wrong with midnight hearings. That's very good. It should happen across the board.
You spoke about the ambiguity in the law, right? Can you just explain it a little bit, the vagueness? Because there is, there are conditions when, the penal provision of the laws do not apply. I think that is when there is a proper 2/3 division in a party. So is that the ambiguous area in the law, or what else it is?
Well, what exactly constitutes defection is ambiguous. When you say you have joined another political party, what all is required to be shown that you've joined another political party? So that is one area of ambiguity. But what you're referring to is the doctrine, the concept of mergers of parties.
That's right. So the criticism is that the law doesn't permit an individual's defection, but permits a group's defection, right?
But there's a history to this,
Could
of course.
also please explain the provision,
The provision
the exception
also,
a bit for
Yes.
the viewers.
Okay, so in 1985, so there were 2 exceptions to this concept of defection when the 1985 law first came. One was in the case of a split, and the second was in the case of a merger of political parties. The split was when one third of the legislative party decided to split and form another unit. At that point, the law considered, all right, you can have a split and you will not be deemed to be disqualified. But that was abused very often, and they saw that it was an easy way to get around the defection by engineering splits. And there were so many splits that it was rather like, fractured land holdings in India. The 5-acre land becomes, after the 20th generation, 100 square yards. So that is what happened, and splits were happening. So in 2003, I think, Pranab Mukherjee, there seems to be a rather Congress-led thing. So 85 and 2003, both amendments. 2003.
Okay.
2003.
It's subsequent to a law commission report.
Law commission report, but I think, correct. Okay. If I'm not mistaken, it was around that time. I think Pranab Mukherjee
Yeah, it
was
was
the mover.
2003 only.
2003, correct. Of course, 2003 was NDA.
That's what I'm saying. It was the
NDA.
NDA.
I stand corrected, NDA. Yes. So they came up and removed the concept of the split, saying a split is no longer recognized and as no longer a case of exception from the disqualification. So you are disqualified the moment you change your political party. But they retained what is called the merger. Now it is possible for 2 political parties to merge, and either the smaller one will merge into the bigger one, or they will merge and form a new entity, political entity. And that happens often with the way the Janata Dal happened, or the Janata Party in 1977 came through a merger of many political parties, including the predecessor of the BJP. So that happened. So the law countenances and envisages that there will be cases of mergers of political parties. And in that case, it says that you will not be disqualified if the political party per se, not the legislators, but the political parties merge, right? So that must happen outside the house. But what's interesting is, it's not as though that's left to only that which is happening outside the house. Otherwise, it's very easy for the certain political parties to hijack what is happening in parliament. So they could be completely unelected MPs and MLAs who will decide to merge, and their MPs and MLAs who are sitting in the house will say, hello, what happened today? You merged now. So what the law says is, a merger of a political party must also be accompanied by at least 2/3 of the sitting MPs and MLAs saying that yes, this merger has happened. So when the 2/3 of the MPs and MLAs say that merger has happened, that's when a merger is deemed to be happened. Now that is the ambiguity in the law, because you deem it to happen when 2/3 of the MPs and MLAs say merger has happened, but simultaneously the idea is a political party also must merge, right? This is only evidence of merger. The 2/3 MPs are evidence of the fact that the political parties are merged. But it's possible that the 2/3 MPs and MLAs are so far removed from their own political parties that the political parties are saying, no, we're not merging. But the 2/3 MPs and MLAs say, we are merging. So then what happens in that case? Right?
So are we talking about the Maharashtra case?
We could be.
Okay.
Well, the point is, I may be at some point briefed by someone, so I don't want to lose out on a possible brief and answer that question.
Yeah.
Both sides have something to argue, let me say. So
Yes, of course.
I'll give my details later.
So that is where the ambiguity lies.
That is where the ambiguity lies. There are many, many instances of ambiguity. But Bhadra, this is what I said earlier about the constitution. Ambiguity is not a bad thing in a constitution. This law, as I said, was framed in 1985. But the constitution is even older, 1950. We've now had experience of some 75 years with it. If we are to ossify the language so clearly and so precisely that what was said in 1950 inevitably continues to hold the roost 100, 200 years, and I hope our republic lasts longer, then the ideas of 1950 are not at all in consonance with the ideas of 2023. So the whole constitutional scheme would break down because people are different, ideas are different, hopes, ambitions, desires are different. So if the country has changed, but the constitution is stuck, then a constitution will almost break because it will not be able to keep aspirations with the people. It won't be dynamic. So the idea we have is of an organic doctrine of our constitution, which changes its meaning. And that change keeps the constitution in tune with the idea of how a nation is evolving. Some part of how it is evolving also offers itself as a role model, that this is what you should be. This is the better version of you. Right? Equality, fraternity, liberty, justice, the four things mentioned in our preamble.
This is an opportunity to improve.
Absolutely. So that is why ambiguity is good, because you can't, if words are not ambiguous, there is no scope for organic growth. But it's when they're ambiguous, that is when there is scope for ambiguous growth, also growth for bank balances of lawyers. Let's not diss that.
Right.
Okay. Before we move on to whether this law has actually grown or has seen ambiguous growth at all, you mentioned that for defections to happen or for defectors to actually be disqualified, their conduct outside the house can also be taken into consideration. Now, this is an argument that has been raised before, especially in the Rajasthan case as well, where some legislators felt that this sort of hurts their freedom of speech and expression outside the house. What do you have to say about that argument?
So I'll just, I have a question to add to it. So there is a lot of criticism with regard to this law, in the sense that many people say that this law actually stifles, debate within a political party and also in the parliament, because this law is often used by political parties to impose their thoughts on their leaders, and that kind of, prevents an open and a free debate inside the parliament. So if you could just address the two questions together or...
Yeah. No, I think they're kind of similar, and that is a criticism of the anti-defection law. And I myself, as a citizen of our country, would put myself firmly in that camp, saying that we have a system of, and under our constitution, of separation of powers. Now, clearly the judiciary is out of all of this. So then there is supposed to be a distinction between the executive and the legislature. But how is that distinction reflected? The idea when the constitution was framed was that MPs are elected by people to the legislature and they are accountable to the people. In turn, the executive, which is the Prime Minister and the Cabinet, is held to account by the MPs. So there is a two system of checks and balances. And the MPs will call into account the actions of the executive and say, here you are right, here you are wrong. It is a form of check and balance of the executive as well. So you have check and balance by the courts, but even Parliament is supposed to exercise a check and balance on the executive acts. And that's what stops Lord Hilsham many years ago said, we have an elective dictatorship in our country. In England is what it was said. That you become elected and you become all powerful as an executive. And that is the problem with parliamentary democracies. But the moment you have an anti-defection law, which says that an MP will not have freedom to decide how to vote, snaps both these links. The link of accountability between the people and the MP, as well as between the MP and the executive. Right. Because the MP can no longer control the executive because the executive is telling MP how to vote. Right. So what control? You have no freedom. And again between with the people and the MP, because the MP is supposed to be the representative of the people who voted for her. But people, the electorate could be saying that, look, what is happening is wrong, don't do this. But the MP will say, my hands are tied, I have no option. A whip has been issued. Right. And therefore, you are no longer representative of the people in Parliament. You are the representative of a political party in Parliament. So that is contrary to the doctrine of separation of powers, which is necessary as a check and balance system, which was envisaged. But more than that, I think, as you rightly said, it stifles dissent. Now, dissent is an extremely important thing, especially in parties which are otherwise large and powerful. And the larger you get, the more discussion, the more it's like it's a cake. Now, if you slice a cake thin and you remove a little piece, the balance is one political party that has a worry of there being a hegemony. But luckily, we live in a system where even in a larger political party, there are different points of views. You have different people, different strains of thought. You'll have the more moderate, you'll have the more left, you'll have the more right, a big tent as we call it. But the moment you have an anti-defection law, then the view of the person currently in control of that party, which may be out of step with the majority of the party also, right? That holds rule. So there is no accountability within the party, there is no accountability within the executive, there is no accountability between executive and the legislature, and therefore I think this is really antithetical to the concept of how democracy was meant to function in our country. And if I may say so, if this had resulted in a clean politics, maybe it was a price I was ready to pay, because after all, these are all social experiments, political experiments. You try different things, nothing is always shown to work. And it's okay to have a separation of powers which has gone away if you get a system, as Rajiv Gandhi said in 85, first step to cleanliness. But history and experience has shown us that that has not been delivered. So we have a system where the anti-defection law, with the greatest respect, has possibly failed in many aspects in stopping defections. It's not as though defections have stopped. Defections are happening every day. So defections are happening, so that problem has not stopped. Yet we have given away that power of control and freedom of dissent. I don't think that was a price worth paying.
So 35 years after the law was enforced, it was primarily enforced for bringing stability in governance and probity in politics. So has it really been successful or not?
I think there's 3 smiles on this. Well, I think your viewers are very intelligent. After all, they're watching, hearing me speak, so they must be intelligent. No, they've watched the print, so they must. But the point is, I think we all know that horse trading has not stopped. Ayaram, Gayaram has moved from Haryana to Goa to now all across India. It's become a pan-India problem.
I think it's becoming an annual affair. So there is an election in any state, and the first thing that comes into the mind is, okay, so
correct.
Let's save them. Take them to a resort.
Exactly, and there are shenanigans before the elections, after the elections. No one can be certain. So this has stopped no form of defection.
So then, what is the alternative, and is there a need for an alternative?
I believe there isn't. The fact is, we in our country like to ban things, thinking that if we say stop, the problem will go away miraculously. As long as you have a certain kind of politics in play, and you have a certain kind of person being elected, a person who values her position more than the idea of public service, then no one can stop that particular person from jumping ship and being dishonest to her electorate. What you need is a better form of politics. How that will come across is probably another matter of debate. But the fact is, as long as that doesn't happen, anti-defection law is not going to solve anything. It's like putting a band-aid on a ruptured artery. It's not going to stop it. So in the meanwhile, therefore, I think anti-defection law should be really seriously considered, and there have been suggestions on it. One way could be is that, and there were many suggestions, is maybe water down the anti-defection law. That not in every case when you vote against the whip is anti-defection law to be used, but only when the stability of the government is at stake.
Right.
So when a no confidence motion is moved, then you must vote in a particular way. Or when a money bill is moved in Lok Sabha, which the defeat of which will result in the collapse of the government, then you can have anti-defection law. But you have anti-defection law even in Rajya Sabha. Now government can't be defeated in Rajya Sabha, no matter what happens. Because the no confidence only happens in Lok Sabha. So maybe that kind of amendment is now needed, is that in matters of determination of stability of a government, you have anti-defection, but not in everything.
Right.
That could be one way of doing it, or else scrap the whole law altogether. I don't think that's going to happen.
With this, we've reached the end of this episode. The law, as I mentioned earlier, was brought in for probity in politics, like Bhadra said, for cleaner politics, like Saurabh said. But as per Saurabh, the law has failed. He does have suggestions. He thinks that the law could be watered down. He also thinks that the law could be scrapped. But you let us know what you think about the law, maybe in the comment section. And like I always tell you, do let us know what you think about this show, about this episode. If you have any laws that you would like us to take up with an expert that you would like to see on this show, do let us know about that as well. Thank you so much for joining us.